Good
Today
morning.
I'll be speaking on a different
Good morning,
aspect,
madam.
not related to. Good morning. Good morning. The topic today I'll be dealing with is, applicable for everyone, especially the researchers and teachers working in various colleges and universities, to make us understand what is IPR, or the short form of IPR. The full form is the intellectual property rights, and to create awareness, and why should we know about IPR, or the intellectual property rights aspect. Okay, so the background for this is that, what is this? Well, in the university, there is some problem.
इधर ला ಮೇಡಮ್.
Is it visible now?
ಮತ್ತೆ ಮತ್ತೆ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದೇನೆ ಮೇಡಮ್, ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿತ್ತು. ಮತ್ತೆ
Yeah,
ಪೋಸ್ಟ್.
I got
ಪ್ಲೀಸ್
disconnected.
ಪ್ಲೀಸ್ ಕಂಟಿನ್ಯೂ.
Okay, so we'll try and understand today about the IPR aspect.
ಥ್ಯಾಂಕ್ ಯು.
Okay, um, just a minute.
ಆ ಸ್ಕ್ರೀನ್ ಶೇರ್ ಮಾಡಿ ಮೇಡಮ್.
So before we start to understand what is this intellectual property right, I would like to draw your attention that most of us who are teachers, we are also researchers. So we conduct a lot of research, and these all these are interlinked aspect. Like, when you conduct research, obviously you will not be sharing all the details with everyone. That becomes one form of patent protection. And then if you really want to apply, then you will go in for patent application. Then that leads to the development of that patent. Okay, and then it may lead to manufacture. For example, if you have developed a prototype of some machine, which could be as simple as making a chapati pressing machine, but that know-how is with you, so you will share it with others who want to take the technology, and that becomes manufacture process. And then ultimately it will be released into the market. That machine or prototype will be released into the market, and whatever earnings come, it goes to the person who has created or discovered or manufactured that, and it will also be shared with the one who markets that particular prototype. So this is a continuous cycle, like interlinked, I would say, relation between an invention, patent rights, and economic development. So patent protection or application of patents also contributes to economy. So with this initial understanding, we will proceed with the rest of the presentation. So what is this?
Excuse me, ma'am.
Yes.
Ma'am, our presentation is not visible.
Not visible?
Yeah, ma'am.
1 minute. Is it visible now?
Yeah, ma'am, it's loading. Yeah, ma'am, it's visible.
Okay, let me go back. So this is what I was just describing about. With this basic understanding, we will proceed with understanding the whole aspect of intellectual property rights, that there is a relation between an invention, patent rights, and economic development. See, we might be questioning ourselves why we are teachers, why should we know about patent protection? But there is a relationship, and it will also contribute to the economy of the nation, apart from fetching some dividends for the inventor. So we will now move on to understand this. Intellectual property has many distinct types. That is, you can apply for patents and even protection of plant varieties if you have done hybridization. Then patents is one, copyrights is another, trademarks, trade secrets, models or designs, etc. Now, patents, like, it could be for an invention, a discovery, or a mechanism of action, or even a plant variety or a method for investigating something. All that it can be content for patent filing. Copyrights is for literary, artistic, and musical creations, and trademarks is for names and logos, which we will go on to understand. Then trade secrets, some formulas and manufacturing process or trading methods. So if it is this, then it becomes trade secrets. And then models and designs, like we have so many models and designs, not to forget with respect to automobile industry. So we relate very well with the models and designs, and that contributes to the aesthetic sense also. So here we can say these are the different forms of IPR. When we say patent, it doesn't include all. Patent is one form of the IPR, intellectual property right. You have copyrights, trademark, industrial designs, even geographical indications are included, plant varieties, and trade secrets. So, industrial designs, what are these industrial designs? It could be any design or shape or pattern. That it could, for example, it could be a manual thing or a mechanical. Example, a design of a chair. Now you have so many Godrej chairs, or I mean, Godrej is a company, or you have Neil Kamal and various other brands are there. So they have a different design, and that design is never copied by any other manufacturer. So that is a claim on their industrial design. And patents is a monopoly right granted to a person who has invented a product or a process of making an article. For example, pen, the fountain pen or the ink pen or the gel pen and various types of pens which we are using also have been awarded patents. So as simple an invention as a pen also is a monopoly right granted to the person who has invented that product, or who has created that process of making an article or an item. Then trademarks, they can be label, or the name, the brand symbol used by a company. See, Puma means what comes into our mind, Nike. So these are all trademarks. And the company does this to create a unique identity for the product. So trademark is registered and it is used as TM, a short form of TM. You can see there will always be a circle like that and small TM in the superscript. And the trademark which the company has applied will be valid for 7 years, and again they will have to renew that. It is like creating a monopoly, saying that nobody should infringe and they should not use that symbol for any of their product. Then trade secrets. Now it could be any intellectual work or product used for business purpose. So here, why some companies are successful and why some are not is again their trade secret, and that trade secret will remain with only a few select people of that business or the company. And that is what is, we can say, is the product of the intellectual work, and which is used specifically for their business purpose. And geographical indication. Now this GIS is also emerging as one more IPR aspect. See, you know of Kolhapuri chappal or Pochampalli saris, Kanjivaram saris, Gadwal saris. Like that, we have typical, some even petha, the Agra petha, or some of them, they are very specific to, they have emerged from a specific region. So the geographical indication originates from a definite area. So example, these, and when you apply for a GI, that will be valid for 10 years and they need to keep renewing it. Then comes the other IPR aspect, and that is copyright. Now, copyright is a negative right which prevents the appropriation of a person's work. Like, I have created something. I have created I have composed a musical, I have a musical composition. I have choreographed a dance. I have scripted a drama. Then I have a script for a drama or a serial or something. Then I have created a sculpture. So it protects my right over that creation, and it is preventing from the appropriation of that work by anyone else. Is it visible?
Yes,
Hello?
ma'am.
Yes, ma'am.
Okay. So to understand more about it, copyright ownership, like, what it endows or gives to a person, the author in relation to various categories of works is like, either literary or dramatic work. So if you have authored a book or authored a script for a drama or performance, then the composer would have composed a musical, theme or a tune, then artistic work, and photograph also. Even cinematograph films produced by film producers is subject to copyright. Sound recording, literary, dramatic, musical, or artistic work, so all of them are subject for copyright ownership. Normally the owner of the copyright will be the author of the work. He will be the first owner, and there will be along with him a team also, because it cannot be just, if it is a music composition, one person alone cannot. So the IP rights can be either registered or unregistered. When registered, they come under patents, trademarks, and design rights. When you don't register them, you can claim them under copyright and unregistered design rights, database rights, plant varieties, GI, etc. Okay, so this is an example for trademark. Now as soon as we see this, we identify that it's a bottle of Coca-Cola. So they have a typical style of writing Coca-Cola. So this indicates the name. Then this is the shape. Even the shape of the bottle is subject to, it's a trademark of that particular company. Now this is an example for a logo type. Now, without even writing the name of that company, with this logo type we identify that it is Nike. Or it could be a symbol like, M, we know what it is for, and this is the slogan which they use below that symbol. And sometimes there will be just a color orange, and this is the trademark of that company. So these are just examples of, like, it could be, the trademarks could be a name or a logo type or a symbol, slogan, shape, or color. So it prevents from others from copying this slogan or this logo type. And the various types of IPRs, as per the Indian Patent Office, you have industrial property, and then you have copyrights and related rights. Actually, under industrial property, there are many: industrial designs, patents, trademarks, trade secrets, geographical indications, layout designs, plant varieties, and farmers' right. Even you can see for GI, geographical indication, the Kolhapuri chappal is included. So like that, these are all examples of various industrial property or types of IPR. So we'll try and understand a little more about the patents, because as academicians and as researchers, the trademark and geographical indications uh, are not our area. Generally, it doesn't come unless you are involved in that. Normally, it is the patent and the copyrights, because there are science people coming from science faculty and from arts, they are liable for filing for copyrights or patents. So, what does a patent indicate, or what does it mean? A patent is a contract between society as a whole and an individual inventor. It's a right granted by the government. So the patentee is conferred rights over his invention for a limited period, exclusive privilege of making, selling, or distributing. So whatever is his invention or process or whatever he has made, that he has the exclusive right of either he himself reproducing it or making it, or he can sell the same prototype or the process or etc., the product, how to make that product or the know-how, to someone, or he can distribute it. So from that, whatever income is generated, that has to be shared between the team of people who are involved. If there is only one person, then There is no question of sharing with others, but the company to which he belongs, like whether it is a university or an R&D institute or any other office or wherever, so it has to be shared between the inventor and the company to which the inventor belongs. So there are different types of patents. One is an ordinary patent, and then a patent for addition or improvement or modification. You might have discovered something or a prototype, then later you will work on it, and you will improve upon it or you will modify it. So there's provision to apply for modification also. A patent granted in respect of convention applications to be made within 1 year from date of application. So you can get your whatever application you have designed, and within 1 year you will have to get the patent granted. So there are different types of patents. So product patent and process patent are the two types which are generally applicable for researchers and academicians. Product patent, protection given to the end product of a discovery, and process patent, it confers protection on the process. So patent confers protection, exclusive right to exploit, right to legal action against infringement. If somebody has copied that and then claiming that it is his invention, then a patent gives us that right to go in for any legal action against infringement. And we can even claim damage for the infringement caused by the person who has infringed. So how to secure a patent? There is a specific process. Like first of all, you have to work on that, whatever is your creation. And then you will have to seek protection. Then it has to be utilized. You have to demonstrate the end result. Then you have to exploit in the sense allow people, others also to use and benefit out of that. And enforcement of the patent gives you exclusive right and the right to assign to whomever you want. You can ask them to use, or you can sell the technology. So patents naturally will protect the invention. So why do you need a patent? If you have invented a product, you want to market yourself or sell to a manufacturer. You believe someone else could sell the product by copying your inventions. So this is the reason why you need a patent. And patent application must include in-depth description of the invention. Like for example, I said pen. Now everything has to be described, starting from where you fill the ink and how the ink will draw, and the whole process of the flow of the ink, etc. Everything and each part of the pen has to be described properly. So drawing of the invention, then completed declaration for patent application, and notarized statement from the inventor. And then you will file, you'll pay the fee to the Patent and Trademark Office. So the pathway is a little long. You have to file a disclosure document. That is where you are going to reveal everything about your product. Then you can file for either a provisional patent or non-provisional patent. Now, provisional patent is always preferable because it protects your ideas while talking to the manufacturers. And you can use the term whenever you want to sell that, patent pending if you use, that means it is giving you some protection. And but one thing is, provisional patent application is valid only for 12 months. After that, you have to go in for a non-provisional application. So this non-provisional patent application gives you the exclusive rights of patent. So that means the patent you have applied for will hold good for 2 years of protection, and that means no one can infringe upon it. So once it is infringed, what happens? That is, it is used by a person other than the patentee or to whomever you have assigned or the licensee. Then you can go in for some civil remedy, like you can file a lawsuit, okay, for damage, and then you can even claim the account of profits. So these are all the various types. This again is a slide which shows various types of intellectual property. Patent, copyrights, trademarks, designs, geographical indication, and even traditional knowledge is subject to patent. Trade secret and confidential information, and even plant varieties are all various aspects of intellectual property. So this is what I was talking of, the process of patent. You submit the application, or you can assign someone, or you can hire a legal representative. then the patent officers who are trained, who are professionals in examining the patents, they will examine our patent and try to verify. This process is called as prior art search. Okay, so when you disclose the invention in using an invention disclosure form, the legal representative or the patent office will give you a invention disclosure form. In that you have to disclose everything. You should not withhold any information. And that once you submit, they will screen it for prior art search. What it means is like, has this patent, I mean the content of the patent, has it been already filed by someone? Is it existing? Now, are you filing for patent rights in India or any other country? So then it varies from country to country. So there is no one international patent. You have, if you want to patent it and for use in US, then you will have to file for patent in US IPO office, so that they will examine whether such a prototype or a product or whatever has not been created by anyone in US and that has not been patented. Okay. So then communication of objections, if any, to the applicant. So when the examiner examines and says that it is patentable, then there is time for anybody to file objections also. Then it will be advertised in the official gazette, and it is open for anyone to oppose, that is objections or anything. And after some time, only when they are very sure that there is no opposition, there are no objections, then only the patent will be granted. Now, the journey from here to here can be quite long, 2 to 3 years also it can take. Okay, so the term is about 20 years. Like, for how long is it valid? It is 20 years for general type of patents. If they are patents based on some food or medicine and drugs, then they are valid for 5 years from date of sealing and 7 years from the date of patent filing. So it is short term, because again, drugs have to be modified. So a lifelong patent is never given for these kind of life-saving drugs, etc., and medicine. So what all is patentable? So now the question for us is to understand what all can be patentable: the art, the process, or the method of manufacture, the machines, the apparatus, or any article, even something like a fan or a hand fan or anything also can be patentable. You would be very surprised. If you're curious, you can just check out the type of articles which have been applied. See, don't assume that whatever is applied for patents will be granted. Not all will be granted, but very silly things also have been patented in various countries, especially in US. However, it should demonstrate the use of it, and it should be successful, and it should show that whatever, for whatever reason you have made that article, it should be usable. Okay, then substances which are produced by manufacture, under substances, drug, medicine, bioactives, and various other comes, and method of testing a manufacture and method of treating a plant. All these aspects are patentable. What is non-patentable? Diagnostic procedure, therapeutic procedure, and surgical procedure. Just imagine if a diagnostic procedure, like a simple thing like testing blood sugars, testing lipid profile, if that is patentable, so then what will be the state of all the people who need the diagnostic test? So every time we will have to pay a huge fee to the one who has diagnosed that method, that is method of analysis of hemoglobin, or any, even the CT scan or anything, it would have become even more costlier. So these diagnostic procedures, the therapeutic procedures, and surgical procedure. Imagine if one surgeon has come up with a procedure for doing some surgery. Then if that is patentable, every time another surgeon in any part of the country has to use that surgical procedure, he has to obtain permission from that surgeon, and only then he can do. And in times of emergency, it cannot be, you cannot wait. So therefore, surgical procedures are not patentable. Then plants, animals, and essentially biological processes, except microorganisms and non-biological production of plants and animals. Yeah. Okay, so then even the method of agriculture and horticulture is also non-patentable, because the very objective of agriculture cultivation is that it should be, the food, the produce should be available for everyone. So you can't patent method of agriculture or horticulture. Atomic energy cannot. India's traditional knowledge, but there are some small aspects which can be, traditional knowledge can be patentable, but not as a whole, India's traditional knowledge. And then mere scientific principle or abstract theory, like you have a thought in your mind, you have an idea. Ideas are not patentable. Abstract ideas, abstract theories are not patentable, or just a assumption, a hypothesis is not patentable. So new property or new use of a known substance, something is already existing, but you have tried to you have found out you can use it for some other purpose also. So that concept is not patentable. And some of the examples of patents filed are neem for its antiseptic and antimicrobial property, the turmeric for its anti-cancer and anti-inflammatory effect, basmati rice, then methi, jute, bt cotton, cow's urine for its therapeutic properties, wheat, and even some of the drugs for, no, I'm sorry, not the drugs, some procedures, some aspects of diabetes also have been filed for patents, but not all have been granted. So what has India done in this regard? We have got many acts. Now you need an act for it. So you have the Indian Patents and Designs Act, which came into being as early as 1911, and then the Patents Bill was passed in 1953, which was improvised again in 1965. Then Patents Act was introduced. It is Article 39, and in 1970 it was introduced. Then you have a Repealing and Amending Act. Then from time to time we can find that there is an improvement and an amendment in all these patent bills and acts. Then we have the Trademark Act, the Copyright Act, the Geographical Indication of Goods Act, Plant Varieties and Farmers' Right Act, then the Semiconductor Integrated Circuits Layout Design Act. So to protect various types of industries, these different types of acts have come. Then not to forget the Information Technology Act and even the Biodiversity Act. So let's try and understand what are the various issues in science and technology. Like, it is not as simple as you come up with some idea or some discovery, some invention you have done. But along with that, there are legal, ethical, and political issues also, which could be at the local level, national level, and it could also be of international importance. So patentable inventions in science and technology are biological materials, laboratory processes, and even pharmaceuticals. Okay. So there are something called as bioethics. That is the moral relevance of human intervention in relation to all forms of life. So there is something, ethics has to be followed in research also. And the same comes, gains more importance in respect of biological sciences. So there are the ethical and legal aspects, social and cultural dimension of life sciences, and the technologies which are associated with them. So the major issues which are governing today the life sciences and medical sciences is cloning of human tissue for treatment, or even in leukemia, etc. Then genetics, genomics, proteomics, DNA sequences, and genotypes. Then stem cell research, like we have read enough and we have heard enough that stem cells are can be used in treating, and it can be used in treating especially many of the life-threatening diseases, and they can use the human embryonic lines for treating many human diseases. Then xenotransplantation, there has been a suggestion from some of the scientists across the world where you can try and use animal organs to transplant in humans. So this is called xenotransplantation. These have not been approved and not permitted. Then biodiagnostics and biotherapeutics, these are not patentable. As I mentioned earlier, a diagnostic test or a diagnostic kit is for use by everyone. So you can't. For example, just imagine now in these COVID times, if that RT-PCR or the antigen antibody testing kit was patented, then it could not have been used for detecting who were corona positive or not. So I want to just talk about a few things. That is, what are the research ethics with reference to certain examples. Now, you have a center called Hastings Center in the US, which focuses on patenting of essential drugs for conditions such as HIV and AIDS. Now, the patenting and licensing of biological materials such as genes and stem cells, they involve. But then later, it was ruled out that you can't patent the drugs for HIV and AIDS. Again, HIV and AIDS is a life-threatening disorder. Then for stem cell research also, there has been an alliance, and their main aim is to advance stem cell research and educate the public about its potential and progress. So they are not involved in filing for patentings. Then there is this LC research program. The E stands for ethical, L stands for legal, S for social, I for implications. So, sorry, this is the LC Institute, Ethical, Legal, Social Institute Research Program, which is looking after the national human genome aspect. So, this manages the genetic research. But now we know what are the total number of genes present in the human being. Now, if somebody files for that, the National Human Genome Project Coordinator files for a patent, saying then only he will know the information that how many genes are there and what gene is responsible for which function or which enzyme or which synthesis of what. Then the whole purpose of doing the National Human Genome Project would have been reduced to it would not have been of use to others. So biotechnology, what are the research and applications? Agriculture and food, we can apply the knowledge which is generated out of biotechnology research in agriculture and food, biomedical and tissue engineering, bioremediation, biotherapeutics, genomics, and stem cells. So the IPR in Indian system, we have different bodies which I'll be talking about. You have the TIFAC, Technology Information Forecasting and Assessment Council. These are outcome of DST initiatives. These are. Then you have the Biotechnology Patent Filing Facilitating Center, outcome of DBT. Okay. Department of Biotechnology, New Delhi. Then you have NRDC, National Research and Development Corporation, situated at Delhi, head office at Delhi, but with various branches. Even there is one NRDC office in Bangalore. Then you have NIFC, National Intellectual Property Rights Facilitation Center, because see, this patent information is not an easy information to understood by everyone. So you need specially trained professionals in patenting rights in order to provide us this information. Pramila, Baglako. Okay. Then you have CIPRA, Center for Intellectual Property Rights Research and Advocacy. Okay. So the main objectives of all these different IPR system, which are used offices in Indian system, which are operating, is to introduce patent information as a vital input to promote research and development, to provide patenting facilities for filing both Indian and foreign patents, creating awareness and understanding among scientists relating to patents by conducting workshops, seminars, and conferences. So TIFAC, as I mentioned, they bring out monthly bulletin on IPR, and they keep track records of the patents which have been granted in India. So far, they have filed about 300 plus patents, both in India and abroad. Now, this is how, like if it is for a DST funded project and whatever is the outcome of that project, so you have to file, if it is patentable, then they will facilitate, TIFAC will facilitate the filing of patents through their patent office. So then the patent information centers in 20 states, they maintain the information from across 20 states, and then all this database is available on CD-ROMs. Then the other patent office, which I said, BPFC has also facilitated filing of patents. So far, about more than 100 is what the information we have. And see here, 100 have been filed, but only 10 have been granted out of that. So they are also in the process of creating awareness and training the scientists. This is in the National Law School. Then other patent offices. Now you should be knowing about where are the government patent offices in India. We have in 4 jurisdictions, and Kolkata, the head office is in Kolkata, Mumbai, Delhi, and Chennai. So the jurisdiction area for Mumbai office is Gujarat, Maharashtra, Madhya Pradesh, Chhattisgarh, and the Union Territories, Daman and Diu. So people from this area should file. So Mumbai office takes care of the patents or copyrights or trademarks or whatever which has been filed coming from these states. And Delhi office, the jurisdiction is Haryana, Himachal Pradesh, Jammu Kashmir, Punjab, Rajasthan, Uttar Pradesh, Delhi, and the other territory, Chandigarh. Chennai, Andhra Pradesh, Karnataka, Tamil Nadu, even Kerala comes, sorry. Then the other Lakshadweep and Pondicherry Union Territory. So anything left out, rest of India is the jurisdiction area of Kolkata. Invariably, all these 3 have a contact, the control is from Kolkata only. So in Kolkata is the head office. Now, I just wanted to tell you about how we can acquire more information. Now, there are there are special institutes. One such is Rajiv Gandhi National Institute for Intellectual Property Management, and this is situated in Nagpur. Here, there is a extensive facility where you can take courses. You can enroll there and take courses, and you can become a patent officer, patent filing officer, patent scrutiny officer, etc. Like, because this is a very different area. So to this particular institute is working round the clock, and they also do training. They train people also here, short term or long term, etc. But there are courses also, and but they don't help you file patents. This is one thing. Then you have NRDC. What is it? National Research Development Corporation. As I mentioned earlier, the head office is in Bangalore. There are offices all over India, one in Bangalore also. They bring out a magazine, about invention and intelligence. This is the recent one with emphasis on the COVID-19. And they have helped. In fact, NRDC helps filing patents. So the latest one, what they have done is the technology offer for COVID-19, Navrakshak, a low-cost breathable PPE suit. So, or it could be anything, but this is one example of the latest patent which they have facilitated in transferring the technology. Navarakshak. Okay, so if you are interested, you can just Google and get this information on NRDC. And I thought it is very encouraging to share this one, like who has more patents. Now, it's very surprising and very gratifying also to know this. It is an Indian origin scientist. He has more US patents than Thomas Alva Edison. Now, Thomas Alva Edison has about 1,039 patents. And this gentleman, Gurtej Sandhu, he is an IIT alumnus. He studied in IIT Delhi. He is an alumnus of this institute, living in Idaho, US. In the past 29 years, he has about 1,299 US patents, not Indian patents, US patents to his credit. So this is something for us to feel proud and celebrate about. Some information about what is the status of the patents. Patent analysis reveals India's steady growth in innovation across all industries. Now, there are top 5 technology areas in India which prioritize patents publishing are computing area, computers, polymers and plastics, communications, pharmaceuticals, and electric power engineering. Here you can see that the bar graph for computing. Okay, So the top technology areas are computing, then polymers, then you have communication, pharmaceuticals, electric process engineering, food, water, and biotechnology, chemicals, and the last one is the semiconductor. So these are all the various industries which are filing for patents, and these are the top 5 technologies are these. And this is the process of filing patent. Now, this is a better figure. Now you will publish. Okay. Now, once you publish an article or your discovery, then you can file for protection so that nobody copies that, and then you can still get a patent. But once the whole details of your formula of everything has been revealed, then there's no point in applying for patent. So you have to apply for patent and then go in for publication and saying that uh, pending patent grant or something like that word will be used. So you can file for provisional patent, then it will be examined, then you will get the response from the patent office. Then if they ask additional information, you may have to amend and give that, because it is these people, the patent officers, they have to be convinced that your thing is patentable, and we have to provide them with all the literature, that is the supporting literature relating to that discovery. Then there is a process called compliance, and after this there's a lot of time between these three. Okay, then only it will be granted. And if there is a possibility of renewal, you can again apply for renewal after 10 years or 20 years. Please remember that all patents don't will not be granted a life of 20 years. Again, depending on the quality of the patent, what type of patent it is, it depends on that. Okay, I want to share you a few two interesting battles on the patent battles, what we can say. This is on the basmati rice patent battle in 2016. All of you know that basmati is something which we'll relish for making biryani, pulavs. This is the rice we use. What does the name? And it's definitely a Hindi name. Basmati. Bas is the fragrance. So it is, Padmavati and Hemavati, or it means queens, isn't it? So it is the queen of fragrance. So this has originated earlier because Pakistan was part of India, so we can consider it. So it is, the origin is from these two countries. And there are many varieties, Indian varieties and Pakistan varieties now we can talk of. So this is just examples. These are numbers which are granted for the varieties. So Indian varieties are these, and then you have Basmati 198, various other things. So all this is used in the identification of Basmati rice. So what is so interesting about this Basmati rice? We are all familiar. But what happened was in 1997, an American company called Rice Tech Inc. Incorporation, they were granted a patent by the US Patent Office to call the aromatic rice grown outside India as Basmati. And India objected to it. Obviously, we can't be sleeping, because this is the origin of this variety of rice is from India and Pakistan. It is not from it is not at all a US product or US vegetation. India has been one of the major exporters of basmati. So we have been exporting, I think, from many years to about 130 countries. That is what it says. And basmati is traditionally grown in India and Pakistan. And it was opined that granting patent to this particular company, Rice Tech, violated the Geographical Indications Act under the TRIPS agreement. So their claim was this Rice Tech Incorporation, they claimed that the aroma was developed by them, whereas it is completely wrong. The claim was that this is wrong. That variety of rice has the typical aroma because of the genes involved in it, and it is natural. And so it took back, ultimately we won, and Rice Tech Incorporation took back all the 50 claims, 15 claims out of 20. One was this, and they also withdrew its claim on the name Basmati on that rice variety. So there's yet one more example I would like to share. Turmeric, the good old turmeric we all use in our daily preparations, and we also use it on the face. It has got antiseptic, antimicrobial, and many other medicinal properties. Turmeric has a component called curcumin, which is anti-cancer. So what is the issue about this turmeric? There was a patent filed in 1995 by a University of Mississippi Medical Center, and the patent was awarded to this center for use of turmeric in wound healing, which was not a new discovery. This was an age-old thing which was known in Indian traditional medicine. So, in response to that, the CSIR Director General, Dr. R.A. Mashelkar, he immediately and promptly challenged it. And this was a big battle, and it was a big scientific battle, I could say. So he promptly challenged this. So the lot of information had to be submitted, and the gist of it is that where turmeric has been used medicinally for thousands of years, and we all know that it can cause a lot of economical and social damage if that patent has been will be accepted in all countries, and particularly US. The CSIR chief argued that turmeric has been used for thousands of years for healing wounds and rashes, and thus its medicinal use was not a novel invention. It was not that Mississippi Medical Center for the first time invented or understood that it has got healing properties. Their claim was supported by documentary evidence of traditional knowledge, including the ancient Sanskrit text and papers published in JAMA. So they had to submit a lot of information in support. Documentary evidence had to be given. So the patent was granted. This is the patent number. It was granted in May 1995 to the Mississippi Medical Center. And upon CSIR's request, it was re-examined at the US Patent Office in 1996. And the first office action rejecting all patent claims were declared in March 1997. So it took about 2 years. So the second action report also, they could not stand there, and re-examination, and then it was the proceedings were issued in favor of CSIR in 98. So it was 3 long years, which it took 3 long years for the withdrawal of the novel invention, which they claimed that it has got a healing property, whereas it was well known, and from centuries it has been used in India for wound healing and rashes and various other. So this landmark case filed by CSIR, they are also, I mean, after that they have become more alert, and they are trying to prevent occurrence of such cases in future. So they are directing a creation of massive database. So once created, it will deny any biopirates. Now we have heard of pirates in different areas. Now in case of the biotechnology, medicine, and bioactive and nutrition, etc., in all these areas also there can be biopiratism. So to prevent all this, the CSIR is taking action. So here I just wanted to share this. It's available on Google also. But from 2012, I apologize for the poor quality because I had to copy it from the net. So to 2012 to 2017, the patents filed between in these 5 years. So the light blue is here, India. I think this one, yeah. So the rest of it is like China and North America and United States. You can see that in the years to come, it is China which is topping the list of patents being filed, and also many in European Patent Office have been filed. But among all of that, not all patents will be granted. You can see number of patents granted. So though in the previous slide, the number filed by China were high in 2012, now you can see that they are not as high as the other countries. So there again in 2017, you can see more and more have been awarded in China. So we can see that there is a steady growth in the number of patents granted. So intellectual property rights are recognized as the yardstick of techno-economic growth of the country. Now, why is it we need protection of intellectual property rights? Because if you have invented something, you have discovered something, and that is the product of your intellect, and that has to be protected, and it has to be exploited for beneficial use of the common man, for whatever you have. Okay, so therefore it gains importance in protecting, and also it is recognized as one scale for assessing the economic growth of the country. Then IP is directly proportional to the research and development divisions of the economy. It's like you do the research and publish and just be satisfied. It is not that the R&D institutes are involved in exploiting and in disseminating that information. For example, you have all the CSIR labs all over the country. Then and our own CFTRI, which is in Mysore, so they also have a lot of patents filed for various technological inventions. Patents are a critical competitive arm in this cutting edge competition, and it needs a huge investment, of course, because the patent filing fees is not small. For the patent search itself, they charge companies and firms, they charge anywhere between 50 to 80,000 initially. And then provisional or non-provisional patent, it again depends. It could be 1 lakh to 1.5 lakh, or then if it is only in India, it will be between 1 and 1.5 lakh. If you're filing for a US patent, then the fee is much more. And then to sustain that, and then finally, the actual patent filing fee is only in few thousands. Once it is granted, no, it is just few thousands. But the process of all this is quite expensive. But it is very gratifying. If you have a patent, the what is the benefit is that if somebody wants to use that technology, they will have to pay to you, and which you may have to share with your team and with the company where you work. But that is the second thing. But the thing is, many people will be buying the technology. See, now the dosa making machine or the chapati making machine or various such machines or the technology which have been developed by CFTRI or any other R&D lab, that will be given, that is bought by other companies, the small because everybody cannot be investing on R&D, research and development. So that is the revenue which is coming from the sale of that know-how of that machine. Then even the MTR has bought. I don't know whether you know that the tender coconut which we have in the powder form, which is available in the sachet, you can reconstitute. You can add it in water. You will still get the same taste of tender coconut. So this technology was developed in DFRL, which is again in Mysore. Then most of the MTR products, the know-how, that is how to prepare all these rajma chawal or various other kinds of processed food, which can be reconstituted on addition of warm water, especially for use by jawans and all. This MTR bought the technology, so they sold it, so they, which has generated a lot of revenue. So these are all just I'm stating to make you understand that what is the use of filing patents. And it is definitely it will fetch you economic returns. So with this, I would like to thank all of you for listening to this different topic, intellectual property rights, on a Saturday morning. Thank you. So if there are any clarifications, I would be happy uh, to do that. Though I'm not so technically qualified to talk about patent, the basic reason you might be wondering, I'm coming from food science and nutrition background, and how am I talking on patents? The only thing is, in our subject and in biomedicine and in biological sciences, there is a lot of scope for filing for patents. So, you might come up with a unique formula, a nutritional formula, which could improve your immunity, or it can be anti-inflammatory, or it can be used in treating any condition, or in preventing weight loss or something like that, which has a medical use. So that can be patentable. So the whole concept started with this. And now our Mysore University also has an IPR cell. And from the time it has been initiated, I have been the coordinator for this IPR, and we have conducted several programs for creating awareness among our research scholars and faculty, and many patents have been filed. Some we have done jointly with other institutes like IISc and Jawaharlal Center for Advanced Research and other institutes. Even Japanese and Chinese institutes also, some of our scientists have worked in coordination with them, and we have filed, and we have conducted workshops. And I myself have undergone a training program at that Rajiv Gandhi Institute, which I told at Nagpur, in order to understand. Then several two training programs were conducted in Bangalore. There also I attended in order to understand, because this is a very different area and it's a very, very dry subject. I tell you, you need to be, for a science person, it is easier to blend. But even then, it's a very different area. Not like the areas which we are all dealing with or teaching with daily. So again, I would like to encourage all of you, like if you are involved in any research or a work which can be submitted for copyright, please do think about it. And if there are no such cells, UGC encourages every university to have an IPR cell in order to encourage the scientists for doing more and more research and development work. Thank you so much.
Hello, ma'am.
Yes.
Thank you for the wonderful talk. Ma'am, does the research methodology what we use in our procedures, does those can be patented?
Is it your creation?
If it is, for example, if I make any changes.
Small
using the method.
modifications are not patentable.
Okay.
No. See, basically, for example, if you are following a method of extraction of something, which has been an idea of some researcher or a team, from 3-4 decades it is being used, and you are bringing in a small modification, that cannot be patented.